Hi, I'm Daniel. I'm a Senior Patent Administrator at Questel. I would like to talk to you about some of the services Questel provides, namely assisting our clients file Paris Convention and National Phase filing applications. Let's first discuss the different parts of a patent application. There is the title of the application, which is the name of the invention, the abstract, which is a small summary, the description or specification, which is the longest part of the application explaining the invention in full, the claims, which outline the legal parameters of the invention. The claims are the most critical aspect of a patent since they define the scope of what can be protected in a court of law. Figures are any drawings, pictures, or visual representations which may appear at the end of the application, and sometimes a sequence listing is also a part of certain biological inventions. Now let's talk about the life cycle of a patent from application to grant. First, an inventor comes up with a new idea, and then through a patent drafting agent, drafts a patent application describing the scope of the invention. The application is then filed at a patent office, where it undergoes an examination which may take several years until the patent office decides whether or not to grant the application, thereby giving legal protection to the invention. Granted patents usually last 20 years until their protection expires. We mentioned that the application is subjected to an examination. What exactly are the patentability requirements that an application must meet for the Patent Office to grant protection? First is novelty. Novelty means that this idea is completely new and has never been heard of or published at all in the public sphere. Any claim in the application that is not new is invalid. Secondly, the invention must contain an inventive step, which means it is sufficiently innovative and not an obvious idea or solution. Number three, it must have industrial applicability, which means that the invention is useful or practical, that it can actually be created and used. Another requirement is called unity of invention, which means that the claims must describe only one invention. Otherwise, the patent lacks unity and cannot be patentable. By far the most fundamental requirement that a patent application must meet is that of novelty. Patent protection is only granted to original inventions. Any aspect of the invention, as described in the claims, cannot have been previously mentioned anywhere in the public sphere, not in another patent, publication, or journal, or even on Twitter. Evidence of the idea or invention previously in the public sphere is called prior art, and it disqualifies the invention because it lacks novelty. The requirement of novelty makes filing for patent protection a real race to the finish line. Timing is everything, and filing for patent protection is a race against the clock to be the first one to submit the new idea before anyone else. There is no second place when it comes to filing for patent protection. The earlier the date you file your application, the more valuable, and less susceptible it is to being disqualified by prior art. The filing date protects your application from anything printed or published after it. It also prevents others from applying for protection for the same idea. Another aspect of patent protection is that it is limited geographically, meaning one can only get protection in the countries where they file. If you file in the United States, your protection will be limited to the United States. If you file in Japan, it will be limited to Japan. The requirement of novelty, coupled with the geographic limitation of patent protection, create a potentially unfortunate situation. Let's say I file a patent application for my invention in the United States, and it is published. Then later I try filing for protection for that same invention in Australia. What happens is that my application in Australia will be disqualified by my previously filed published application in the United States. After all, the idea is no longer new. Even though it's my own invention, it can still be held against me and disqualifies any later application anywhere else. These various requirements leave us in a difficult position. If we want patent protection in various countries, we must file everywhere we want at the exact same time. Now, when you consider all the various requirements for filing in multiple countries, whether it's translation requirements, various deadlines, all of the required fees and forms for execution, and all this on top of racing to complete the invention and be the first one to submit it, makes filing everywhere you want coverage all at once an extremely daunting and practically impossible proposition. The good news is that many countries signed what's called the Paris Convention Treaty, which allows one to file an application called a priority application in one country, and then have 12 months to file in the rest of the countries in which they want protection. These are called convention filings. The 12 months give the applicant time to meet the various countries' requirements while having already reserved a priority filing date. When one has an invention and wants to protect it, they are racing to get their application filed and secure the earliest possible date so that anything after which would not disqualify them. The Paris Convention allows the applicant to secure this date by filing the priority application in one country and then still give them 12 more months to work out all the other requirements and file in all of the countries in which they want protection. Even though the convention filings were filed 12 months later, they will be given the benefit for purposes of novelty of the earlier priority filing date. In summary, the Paris Treaty allows somebody who files one application another full 12 months to file additional convention filings in any additional countries, while still retaining the priority date of the original filing for purposes of novelty, meaning that anything published within that 12-month period will not threaten the novelty of the applications, since they retain the benefit of the first priority filing 12 months earlier. Every application, of course, will undergo its own individual examination through that country's patent office, and depending on the result, will be granted patent protection in that particular jurisdiction. In addition to the Paris Treaty, many countries went even further and signed the Patent Cooperation Treaty, known as the PCT. This treaty gives the applicant 30 months to file in multiple locations around the world following an initial priority application filing. This is done through filing the PCT application. It works like this. 12 months after the original priority filing, the applicant must file that invention as a PCT application at an office of WIPO, the World Intellectual Property Organization. After that, they have another 18 months to file wherever else they want around the world. In total, this process gives the applicant 30 months from the time that they file their original priority filing application until they have to meet all the requirements and deadlines to file around the world. This process of filing in various countries around the world is called national phase filing. About 6 months after the PCT application is filed, WIPO publishes the PCT application as a document called the WO. It is this published PCT application which is the text that will be filed in each country. Filing this application in each country around the world is called entering the national phase because it is taking this international PCT application and filing it on the national level in the individual nations or countries. In summary, the PCT agreement now gives the applicant 30 months from an original priority filing to meet all the requirements and file in various jurisdictions around the world. This is possible through filing an international PCT application with WIPO within 12 months of that original filing. The individual national phase filings in the various countries will all proceed with their own local examinations, hopefully leading to the eventual grant of patent protection. And again, those examinations will always consider that original priority filing date for the purposes of novelty. While the Paris Convention gives the applicant 12 months from the priority filing to file globally, and the Patent Cooperation Treaty gives 30 months through filing the PCT application, they both afford the later filings with the earlier date of the priority filing application. This gives them the advantage that any prior art published after this date will not threaten the novelty of the application. Aside from the additional 18 months that filing a PCT application provides, another benefit to filing a PCT application is that WIPO performs a preliminary examination. In addition to publishing the PCT application, the WO document, they also publish a search report which identifies any prior art that could threaten the patentability of the application, as well as a written opinion which provides a general forecast of the patentability of this application. This information helps applicants make their decisions as to how to proceed with the national phase filings. So now the big question, where does Questel come into all of this, and how can we help? When a client has filed a priority application and the 12-month convention filing deadline is coming up, or they already filed a PCT application and have the published WO document and the 30-month national phase due date is approaching, and they know what countries they want to file in, now is the time to call Questel. Questel helps clients file Paris Convention filings in the participating countries, as well as PCT international filings at WIPO. Questel also helps clients take their PCT application and enter the national stage in multiple countries. Let's briefly overview Questel's operations for managing direct Paris Convention, PCT international, or national phase filing cases. As soon as we receive clients' instructions, we thoroughly review them along with any included documentation, checking them against the online registers. We check the various requirements and confirm the deadlines. We request any missing documentation or information that may be required. We then instruct our filing associates, providing them with the necessary documents and any special instructions. Our formalities team gathers any forms for execution to provide to the client. We also advise the client if we receive information from our associates regarding any potential issues. Relieving the client of dealing with multiple associates all over the world, Questel acts as the main point of contact during the entire filing process. Questel monitors the progress of the filings and ensures all the requirements are completed by their deadlines. Once filing is completed, we typically transfer the matter to the client's own prosecuting agents in the various countries, who will then work with the client directly during the post-filing and examination phase. Instead of juggling multiple foreign associates, Questel offers our clients a truly seamless filing experience.